Hello everyone. Today we are going to be going over the SPQ. So the SPQ is the Seller Property Questionnaire, California Association of Realtors Standard Form. SPQ, which is Seller Property Questionnaire, is a document designed to help sellers disclose information about the property's condition that might affect a buyer's decision to buy. So is the SPQ required to be used in real estate sales? Yes, it is. Depending on which purchase agreement is used, while no law or statute requires sellers to use this form, the pre-printed language in the car, residential purchase agreement, and other residential contracts require sellers to use SPQ when they're required to also use the TDS. The car purchase agreements that require delivery of the SPQ are the RPA, MHPA, NODPA, and RIPA. The vacant land purchase agreement does not require the delivery of the SPQ, but it does require delivery of a similar form called the Seller Vacant Land Questionnaire. So that would be obviously for vacant land purchases. The SPQ is not required by law, only by contract. Therefore, if a seller did not want to provide the SPQ, then the language in the standard residential purchase agreements would have to be amended, typically through a counteroffer. So if for some reason your seller does not want to fill out the SPQ, it needs to be in the contract that it is not going to be provided. If you're on the buyer side, and you get a counteroffer stating that the seller does not want to fill out the SPQ, then they need to put that in the counteroffer. Or if the listing agent tells you over the phone, email, text, something like that, that it's not going to be provided, it does need to be in the contract as an amendment or in a counteroffer. So just remember that. In the residential purchase agreements where the SPQ is required even if the property is TDS exempt? No. In residential purchase agreements listed in the previous question, the SPQ is required only when the TDS is also required. So basically use them hand in hand. In other words, if the transaction is exempt from requirement to deliver a TDS, then the SPQ is likewise not required. What types of properties are not covered by the TDS or the mobile home TDS law? TDS, MHTDS law applies to transfers by sale, exchange, installment land, sale contract, lease with an option to purchase, or ground lease coupled with improvements of real property or a residential stock cooperative improved with 1 to 4 dwelling units. In addition, it applies to resales of manufactured homes and mobile homes classified as personal property and intended to be used as a residence. Thus, PD law does not apply to residential properties of 5 or more, commercial, industrial, vacant land, or agricultural property. If you'd like to see more information on that, you can refer to the California Civil Code 1102. Are there any transactions involving 1 to 4 unit residential property for which seller is exempt from providing a TDS or mobile home TDS? Yes. Certain types of transfers are specifically exempted by California Civil Code 1102.2. These are as follows. Transfers requiring a public report where no public report is required. Transfers pursuant to court orders, such as court-ordered probate sales, sales by a bankruptcy trustee, writ of execution, eminent domain, and transfer resulting from a decree for specific performance. Transfers by foreclosure, including a deed in lieu of foreclosure and a transfer by a beneficiary who has acquired the property by foreclosure or deed in lieu of foreclosure. Continuing on, transfers by a fiduciary in the course of the administration of the descendant's estate, guardianship, conservatorship, or trust. Note an exception to this exemption occurs when the property is held in a revocable trust, and the trustee is a natural person who is also either the former owner of the property or was an occupant in possession of the property within the year preceding the transfer. Transfers from one co-owner to one or more other co-owners. Transfers made to a spouse or to a child, grandchild, parent, grandparent, or other direct ancestor or descendant. Transfers between spouses in connection with a dissolution of marriage or similar proceeding. Transfers by the state controller pursuant to unclaimed property law. Transfers as a result of failure to pay property taxes. Transfers or exchanges to or from any government entity. Note, even though the seller of residential 1 to 4 property may be exempt from having to provide TDS or mobile TDS in certain situations, a licensee is not exempt and must conduct this inspection and disclose the results of the inspection in almost all residential transactions involving 1 to 4 units. So in this case, you would use form AVID, which is the agent's visual inspection disclosure. It may be used by the real estate licensee for this purpose. Realtors should review the legal article, real estate licensee's duty to inspect residential property for additional information on this duty. This is the link if you would like to visit that at the CAR.org site in the risk management section. Lots of good info in there, but this is a good one to look over here and there just to keep it fresh. If the transaction is TDS exempt, then how does the seller disclose material facts? Where the transaction is TDS exempt, then the seller should fill out and deliver to the buyer the CAR form ESD, which is the exempt seller disclosure. Per the terms of the contract, TDS exempt transactions must use ESD. While there is no law or statute requiring the use of this particular form, the pre-printed language in the CAR residential purchase agreement and other residential contracts does indeed require the ESD when the transaction is TDS exempt. So does the SPQ replace the TDS? No, the SPQ does not replace the TDS. In fact, in every CAR purchase agreement where the TDS is required, the SPQ is also required. The SPQ is given in addition to the TDS. So does the SPQ replace the SBSA? No, SBSA, a form created by CAR, is an optional risk management form. It is a recommended form that may be used in every transaction. However, it is never required by law. If the SBSA is given to either the buyer or the seller, it will be in addition to the SPQ and not in lieu of the SPQ. Which provision of the RPA CA requires the delivery of the SPQ? So you're looking at paragraph 10A, number 4 here of the RPA, and you will see down there at the bottom, it says within the time specified in paragraph 14A, seller, unless exempt from the obligation to provide a TDS, shall complete and provide buyer with a seller property questionnaire, form SPQ. If seller is not required to provide a TDS, seller shall complete and provide buyer with an exempt seller disclosure. So it does state in the contract, SPQ is required. When should the SPQ be completed and delivered to a buyer? The RPA requires by default that the SPQ be delivered within 7 days after acceptance, along with all of the other disclosures. So we're looking at section 14 here of the RPA, and you'll see letter A, seller has 7 days after acceptance to deliver to buyer all reports, disclosures, and information for which seller is responsible. So this is including the SPQ. What rights does a buyer have as a result of receiving the SPQ? Depends on when the SPQ is given and the language of the contract. If the SPQ is given to a buyer before the offer is written, then a buyer can take the disclosure into account when deciding whether or whether or how much to offer on a property or what request to make of a seller during the inspection period. If the SPQ is given after the offer is made, but during the buyer's inspection period, the buyer can take the disclosure into account in deciding whether to make requests of the seller before expiration of the inspection period and whether to remove an inspection contingency or cancel the contract. If the SPQ is given after the inspection period has already expired and after a TDS has already been delivered, it could be considered a material amendment to the TDS or a subsequent or amended disclosure pursuant to contract triggering either a statutory right of rescission or a contractual right of cancellation, even if the buyer had removed their contingencies. So if the SPQ has not been given and a TDS is required, and they have already released contingencies, this could trigger a cancellation still and be within the rights. So keep that in mind. All your disclosures out at the same time within those 7 days. How does the SPQ help the buyer? Because the SPQ may trigger the seller's memory about the property and prompts the seller to disclose information, a buyer who receives the SPQ is likely to have more information about the property than the buyer would have otherwise received if the SPQ was not used. The buyer can then take this information into account when deciding how much to offer for a property, what types of inspections to have, what kinds of repairs to request, or whether to seek other adjustments to the contract, and whether to remove contingencies or cancel the agreement. How does the SPQ help the seller? By providing a more thorough disclosure, either before or during a transaction than may have otherwise occurred, the seller reduces the possibility for misunderstandings with the buyer and, even worse, future claims or lawsuits by the buyer alleging the seller misrepresented the property, intentionally failed to disclose material facts, or committed fraud. Often the anger that accompanies an after-close discovery aggravates a situation that could have been easily resolved prior to close of escrow. How should an agent respond if a seller asks the agent if a particular item warrants disclosure in the SPQ? As a general rule, one can say, when in doubt, disclose. If the seller believes the item is important enough to ask the question, then disclosure is the prudent thing to do. If it turns out the disclosure is not important to the buyer, then it will be of no consequence. If the disclosure is of concern, it's better to resolve the matter prior to escrow closing rather than risk a later argument or lawsuit on whether the disclosure should have been made as a material fact. Does the form prompt the seller to disclose defects that have been repaired? Yes, it does. See section V, seller awareness, subsection C that states, including past defects that have been repaired. So here we're looking at the SPQ, section C of section V, or it's actually subsection C of section V. And you will see it asks, are you, the seller, aware of? And then number 1, any defects in any of the following, and it lists them out. How far back in time does a seller have to make disclosures? The seller should answer the question based on the seller's actual knowledge, regardless of the time involved. If the seller can always specify the time as part of an explanation, ultimately, only a judge or arbitrator hearing a dispute can decide whether the item is no longer material or significant passage of time. A disclosure avoids the issue. If there is ever a question, remember, the state of California wants the buyer to know everything the seller knows. So that is a phrase that I repeat to my sellers during my listing appointments. When they do ask me questions, I always just tell them, the state of California wants the buyer to know everything that you know about the house. Does the seller have to disclose items that occurred before the seller acquired the property? If the seller has actual knowledge, yes. The seller must disclose all known material facts. Once again, if there's ever a question, remember, the state of California wants the buyer to know everything the seller knows. Does the SPQ require the seller to provide certain documents pertaining to the property? The answer is yes. The last question of the SPQ asks the seller to turn over copies of reports, inspections, disclosures, warranties, maintenance recommendations, estimates, studies, surveys, or other documents pertaining to the condition of the property. Essentially, the SPQ requires practically any written item pertaining to the condition of the property to be turned over to the buyer. Here we are looking at that section. This is the last question of the SPQ. Here it is. It's asking, are you, the seller, aware of any reports, inspections, disclosures, so on and so forth? So if they have anything in writing, they should turn it over. Does the SPQ represent an absolute description of the current and future condition of the property? No, the SPQ is only asking about the seller's current knowledge. The question is framed as, are you, the seller, aware of? If the seller is not aware of an issue, then they answer no. The SPQ is not a guarantee of the property's condition, not a warranty regarding of its future status, and not a promise that the seller is either aware of or remembers everything that is asked about. Rather, it represents a snapshot of a seller's good faith recollection about various aspects concerning the property. A buyer should consider SPQ as one item affecting the buyer's decision. It is not a substitute for the buyer's own inspection, judgment, and common sense. Does the SPQ replace other seller disclosure documents that may already exist in certain markets? So in many market areas, local association realtors or brokerage companies or both have created their own documents, either addendum to the purchase contract or TDS, to elicit additional information from the seller. These association realtors and brokerage companies believe, as did the CAR Standards Forum Committee, when it recommended publishing SPQ, that is beneficial for both seller and buyer if information is disclosed during the course of a transaction. Such disclosure helps prevent misunderstandings and allows for open, honest, good faith discussion between buyer and seller. Having knowledge of the availability of other disclosures in use throughout the state, the SFAC recommendation was also based partly on the belief that a statewide standard disclosure can help create consistency among transactions and real estate firms. Whether locally generated documents are replaced by the SPQ or modified as a result of the SPQ depends on management philosophy of, attorney input for, and member or licensee input to the local association of realtors or brokerage company. Rise Realty does not currently have a replacement disclosure for SPQ. Therefore, SPQ is a required disclosure to be executed by both seller and buyer on every transaction it pertains to. Additionally, it is the Rise Realty policy to have CAR Form SPQ fully executed in the event a competing brokerage supplies at their own replacement seller disclosure in lieu of the SPQ. So failure to have the CAR Form SPQ fully executed in the transaction file where a TDS is also required may disqualify the transaction from E&O coverage should a claim arise. So, and that is pretty standard throughout the industry. The E&O carriers typically state that all the disclosures need to be on CAR forms, the contract needs to be on CAR forms, so on and so forth. So just keep that in mind. If you have another brokerage out there sending you some additional disclosures that are, brokerage specific, it's okay to go ahead and have those signed, obviously, but it's our policy to also still have the SPQ signed on transactions where the TDS is also required. So keep that in mind. If you want more information, obviously, go back to the risk management section of car.org. There's additional information there. Hope you learned a little bit about the SPQ.